petitioner is allowed to go on bail of rupees 50,000 with two sureties of like amount with certain conditions.
And it's 6.
Without for reasons mentioned in the order, the prayer for bail of the present petitioner is rejected. However, the trial court is directed to examine all the remaining 6 witnesses within a period of 3 months from the date of this order and expeditiously dispose of the special NDPS case number 19/2023, which is pending before it.
Item 1.
Make resolution. Well, so far as the co-accused is concerned, my lord already had the occasion to deal with the bail petition at page 30, my lord. One of the accused, my lord, he has also approached this honorable court praying for bail in the same FIR, my lord. The FIR, page 30 is the order granting bail to the other co-accused, and the FIR is at page 19. So subject to what the public prosecutor says is, it's a civil ingredient that is brought out in the FIR, my lord. They said that they supplied some betel nuts, my lord, and the money was yet to be paid. And that is how this FIR praying to the police that they also have the receipts also of the supplies made. And they pray to the police that their money should be. It's a civil matter, my lord, and I will appear, my lord, and cooperate, my lord, if my lords and if
How many accused are there?
there are 6 accused, my lord. 5 have been granted bail.
Okay.
And this accused, he was not in station, and therefore he did not apply for the bail earlier. And my lord, all family members, my lord, the 5 who have been granted bail, they are mother, brother, sister, and 2 maternal uncles. My lord, all the family have been tagged in the FIR because they thought that someone should pay the money to them. And if I may,
Yes.
if I may place the FIR also, my lord, I just thought since this honorable court has just come from the division bench, page 19, my lord. Hanman Purboke Binita Nibidan age
Page 19.
19.
Yes.
Hanman Purboke Binita Nibidan age মই মোৰ লগতে অন্য 27 জন লোকে সুপাৰি থলুৱা ব্যৱসায় কৰি আছো। আমি সুপাৰিবোৰ গাঁৱৰ ক্ষুদ্ৰ ক্ষুদ্ৰ স্থানীয়ৰ পৰা কিনি আনি 1 নম্বৰ আসামী ওচৰত বিক্ৰী কৰো। আমি 1 নম্বৰ আসামিক সুপাৰিবোৰ দিয়াৰ সময়ত ওজন কৰি পাব লগা টকাৰ হিচাপ কৰি 1 নম্বৰ আসামীৰ পৰা এখন লিখিত স্লিপ লওঁ। They are admitting that it was in business transaction. তেখেতে আমাক দিবলগীয়া হিচাপবোৰ তেওঁৰ ব্যৱসায় কৰা হিচাপৰ বহীত লিখি ৰাখে। আমি ইংৰাজী ইমান চনৰ জুলাই মাহৰ পৰাই 1 নম্বৰ আসামীৰ ওচৰত সুপাৰি দি আহিছো, কিন্তু টকাবোৰ লোৱা হোৱা নাই। He is not even saying that he is not refusing to pay. কিন্তু আজিৰ পৰা 2 মাহৰ আগতে 1 নম্বৰ আসামী ঘৰৰ পৰা বাহিৰত গৈ ঘূৰি আহা নাই। ঘৰতে বিচাৰি গলে কি বাকি আসামী
You are accused number 1.
I am accused number 1.
Okay, you are the main accused.
my lord, the main accused not of any criminal offense. It is not of any criminal offense, and that
They have
only,
not paid the money for,
yes, that fact remains, my lord. That fact remains. We are
Yes,
not
Mr.
disputing
Bhushan.
that.
Lordship, earlier, that is the order dated 4/4/2024. This is made absolute after perusal of the case diary. And because Lordship, in this matter, he is the prime accused number one. Maybe Lordship, CD is required.
okay,
in this
heard
matter.
Miss B.S. Goyer, learned counsel for the petitioner, also heard Mr. A. Bosho, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Shri Vishal Daga, who is apprehending his arrest in connection with Tongla PS case number 11/2024 under section 420/406/34 of the Indian Penal Code. The next paragraph. The gist of accusation in this case is that on 4/2/2024, one Shri Gautam Dey had lodged an FIR naming 6 numbers of accused persons in the said FIR, including the present petitioner, as accused number 1, inter alia, alleging that the first informant along with 27 other persons used to do business of betel nut, and they used to purchase the betel nut from small sellers from the local villagers, and thereafter used to sell the same to the present petitioner. It is alleged in the affair that though since the month of July 2023, the petitioner has been supplied with
Betel nuts.
betel nuts. However, he has not yet paid the consideration amount for the same.
It is not even, they do not even say they have not paid. They said that they have not taken the money.
Okay, they have not taken the,
Money.
they have not taken the money for the same from the present petitioner. No. On receipt of the said FIR, Tongla PS case number 11/2024 was registered. Learned counsel for the petitioner has submitted that bare perusal of the FIR would reveal that the dispute between the present petitioner and the first informant is predominantly civil in nature. She has also submitted that out of 6 named accused, 5 accused persons have already been granted protection by this court. All are granted bail by High Court.
Yes, first initially interim was granted, thereafter it was made absolute.
Protection on anticipatory bail within bracket anticipatory by this court. She has also submitted that the petitioner is ready to cooperate in the investigation. Hence, in the investigation, and therefore, in the investigation, however, the petitioner is apprehending that he may be arrested in connection with this case, and therefore he has prayed for allowing him to go on anticipatory bail. Stop. On the other hand, learned additional public prosecutor has submitted that as the present petitioner has be named as accused number 1 in the FIR, perusal of the case diary would be necessary. Stop.
For interim. Because the receipts, etc., whatever is there, my lord, I'll produce
No,
them.
we are why case diary is necessary?
Because case diary was already, yes, produced already.
Because 5 are on, and the allegation is that you have not paid my money. No other allegation is there in the affair. I have heard learned counsel for both the sides and peruse the materials on record. Bare perusal of the FIR would reveal that the dispute between the present petitioner and the first informant appears to be a commercial dispute of which is predominantly civil in nature. Moreover, also considering the fact that all other remaining 5 accused persons are already allowed to go on bail, this court is of considered opinion that if the petitioner cooperates with the investigating officer, his custodial detention may not be necessary, custodial interrogation may not be necessary for fair completion of the investigation of Tongla PS case number 11/2024. Stop. In view of above, this anticipatory bail application is disposed of with a direction to the petitioner to appear before the investigating officer of Tongla PS case number 11/2024 within a period of 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Tongla PS case number 11/2024, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. You will cooperate with above observation, this anticipated bail application is hereby disposed of.
I'm so grateful.
The 430 application, my lord. FIR lordship will find page 9. My lord, my name is not in the FIR, my lord. I'm not in the FIR name accused, my lord. But police is behind me, sir. The main accused, my lord, has been arrested and released on bail by your lordship, my lord. May I take a copy of this order, my lord.
Where is the FIR?
FIR lordship will page 9, my lord.
Where is the
My lord, relevant person is my lord.
where is the earlier order of this court?
My lord, the
Co-accused, releasing of the
prime accused, my lord. His name is reflecting, my lord,
who is the main accused?
Abdul Malik, my lord. Page 16 of my application, you also will find.
What is the allegation?
Allegation, my lord, the main accused has collected some family identity cards of some informants, my lord, and they use it for obtaining loans, my lord. Ultimately, it's a forgery, my lord.
And you are not named.
Not named, my lord.
Then why are you apprehending
My
your
lord, police
arrest?
is searching me, my lord, for my lord, no reasons, my lord. That is why, my lord. I will, my lord, cooperate, my lord.
Allegation is serious in this matter
But
because his
There is
name
no
is not, he is not FIR named. So, but
let him appear
My lord.
because he is not named it.
he's not FIR named.
How
TK.
you have given a, is there any statement that you are apprehending your arrest?
Yes, my lord, my lord, I have stated, my lord.
Where?
Para number 3. Lordship.
There are three, my lord. Page 4,
How Mr.
TK, my lord.
P.K. Bhiya, learned counsel for the petitioner, also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Anisur Rahman, who is apprehending his arrest in connection with Nagaon PS case number 231/2024 under section 120B/406/420/468/471 of the Indian Penal Code. The gist of accusation, Code Para 3 from bail application number 1071/24. Next para. Learned counsel for the petitioner has submitted that though the present petitioner has not been named in the FIR, the police is searching for him and he is apprehending that he may be arrested in connection with this case. He has also submitted that in the meanwhile, by order dated 24/2024, passed in bail application number 1071/2024, this court has already granted bail to the main accused, namely Muhammad Abdul Malik. And in view of the same, he has submitted that the petitioner may be allowed to go on bail. It is also submitted that the petitioner is ready to cooperate in the investigation. Stop. On the other hand, learned additional public prosecutor, Mr. K. Bosho, has submitted that though as the allegation made in the FIR are serious, hence perusal of the case diary would be necessary. Stop. Call for the case diary fixing after 2 weeks.
My lord.
30,
34, 35,
35.
35, 2020. However, in the meanwhile, considering the fact that the main accused has already been released on bail, and also considering the fact that the petitioner, that the present petitioner has not been named in the FIR, and he is ready and willing to cooperate in the investigation, the above named petitioner is directed to appear before the investigating officer of Nagaon PS case number 231/2024 within a period of 10 days from the date of this order. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Nagaon PS case number 231/2024, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. Let this case be listed again on 30/5/2005.
I am obliged, madam.
And it's
May it please for your lordship. Lordship, the examination chief of PW1 has not been completed, lordship, because the chief has been further reserved. The matter has been fixed tomorrow in the lower court, lordship. Lordship may kindly call up for the up-to-date status report along with the testimony of PW1, lordship.
Okay. Miss, what's your name?
B. Shetty, lordship.
Heard Ms. B. Chetri, learned counsel for the petitioner, also heard Mr. K. Bosher, learned additional public prosecutor. It appears from record that by order dated 19/4/2024, this court had called for the scanned copy of the testimony of PW1 from the trial court. Stop. However, learned counsel for the petitioner has submitted that the examination in chief of PW1 has not yet completed, and it is fixed before the trial court on 14th May 2024. In view of the submissions made by learned counsel for the petitioner, let this case be listed again after 2 weeks. on 31st/5/2024. The issue reminder for registry to issue reminder for getting a scanned copy of the testimony of PW1 from the Court of Learned Special Judge Tinsukia. Before the next to be placed before this court on the next date fixed, that is 31st March 2024, list accordingly.
Obliged, Lordship.
Report.
Lordship, 4, 7 and 8.
Nothing else.
Lordship, probably today also. I will not permit.
But you start unless we start. Otherwise, what will happen? Because I'm sitting in DB, every day we are getting only
Lordship, this is the difficult,
limited time.
and we are waiting since morning. Lordship. There is no time is fixed.
You are not waiting since morning,
No, I'm in court, Lordship, in different courts.
but you are not waiting for
No,
this
no, no,
case.
Lordship, because we have to wait, Lordship. we
For
have to-
this case, you are waiting since
No, no.
morning.
For Lordship roster, we have to wait for the
Okay, now let us start.
Lordship. First, I want to place the facts of the case. Document-
You are making submission as regards 4, 6 and
4, 6 and 8.
4, 7 and 8. The lawyers are present.
4, 7 and 8.
Mr. Bishwas is there,
I'm for only 8.
8.
Item number 8, I can sum up in 1 minute. 60 seconds, I'll sum up. Item 8, if your lordship takes. Not even 61 seconds.
You have, okay, then you take 1 minute and
Okay.
make your submission.
My lord will
Let him-
my lord will kindly come to page number.
You will get only 60 seconds.
Absolutely, my lord, I will
Okay.
keep my word.
Okay.
Page 50, my lord will take, kindly.
Yes.
Two persons were caught in the trap. One is at page number 50, Sanjay Kumar Shah.
Another is you.
Another is me, and the proof is para 3, page 51. My lord, not even 30 seconds.
Okay.
And this order has not been challenged anywhere. This is holding the field. Absolutely identical, not even half an inch more, half an inch less. Para 3 would say,
And Miss Nargis has already made her submission.
Yes, Lord. Yes, made all
Okay,
right.
This
you,
is myself.
you make your submission.
I'm declared.
Lordship, may please to take item number 4.
Item number 4, just.
First, I'll place law facts, then thereafter, Lordship, I'll go to the judgment part where the different count in the different counsel.
Yes.
Page 63.
Page 63.
Evidence against accused Kajal Devnath. Paragraph 55.
Yes.
This is same as with item number 8. Lord. 8, no?
Item number 8.
Yes, Lord.
Similar to.
Yes.
Page 63, the role of Kajal Devnath.
Yes.
Then page 62 is it with respect to Javed Iqbal, item number 8.
Okay.
Move page 62. Move page 62 है ना?
These are the materials against the both the petitioners. Now Lordship, item number 4. Item number 7, Lordship. Surendra Kumar. Item number 4 and 8 are similar, arising out of the same case. But item number 7 is different. Lordship, we come to page 652.
Yes.
Here, Lordship, the contraband was involved with 117 cases, which is commercial quantity seized from truck bearing number so and so, which was the unconscious position of Surendra Kumar. So these are the facts. Now, Lordship, in all the 3 applications, the ground for seeking bail is, one is, what I understand, Lordship, maybe different on the view of the petitioner also. First, there is a parity because co-accused has been granted bail, so they also be granted bail. And second, delay in trial. Probably, I think these 2 grounds are there. Now, Lordship,
Prolonged incarceration.
incarceration.
Item number 7, medical ground is also.
Hydrocele.
In item number 7.
Hydrocele.
Yes, Lordship.
Okay. Yes.
Lordship, I'm placing one judgment of Honorable Supreme Court in the case of state by NCB Bengaluru versus Pallal Bidin Ahmed. Was pronounced on 10/1/2022. Lordship, we come to page paragraph 11.
Yes.
Married.
Yes.
However, the evidence brought before us against Muhammad Afzal, accused number 2, respondent in the SLP criminal so and so. The subject matter of the second case, that is NCB case number so and so, was who was
Here on what grounds other co-accused were released? from
Lordship,
bail?
that is, it has been explained here.
Okay.
Who was granted bail by order dated 8 January 2022 will have to be treated on entirely different footing. There are specific allegations leveled against the said respondent regarding recovery of substantial commercial quantity of drugs from a rented accommodation occupied by him, pursuant to which he was arrested on 16 June 2019. This aspect has been completely overlooked while passing the order dated 8 January 2022, wherein the only reason that appears to have been weighted with the High Court for releasing him on bail is that his case stands on the same footing of accused number 1, 3, and 4, who has been enlarged on bail by order dated 11th October 2019, 16th September 2019, and 9th September 2019 in connection with the second case registered by the department. We are of the firm view that accused number A2 cannot seek parity with the aforesaid accused, and no such benefit could have been extended to him in view of section 737 of the Act, when he was found to be in conscious possession of commercial quantity of psychotic substance as contemplated under NDPS Act. That being the position, the petition of NCB succeeds in SLP number so and so, bail granted to the respondent Mohammed Afzal is cancelled forthwith at this stage and he is directed to surrender before so and so. So on the parity, the bail was granted to the present accused also, since the bail was granted to other accused. And on last occasion, Lordship, I placed some other judgments, the Tarun Kumar also. Although
No,
they,
in this case, what Supreme Court has said that they were not at parity.
yes, parity cannot be a ground, that is the law.
No, that has not been stated. Supreme Court has said that the accused whose bail is cancelled is not similarly situated
Yes,
like
Lordship,
that of,
the ground of parity cannot be available to the present accused.
because he was not similarly situated.
Yes, Lordship, this is my submission.
That is the
So,
observation.
an overall,
They were
Lordship,
not at parity,
yes, Lordship,
therefore benefit was not granted.
that is, this is my submission. That's why I placed first, Lordship, the facts of the case, then I come to the law. And Lordship is known that the parity cannot be
Okay,
ground,
okay, your submission is that present petitioners are also not at parity with
parity with the
those who got bail.
granted bail.
Okay.
Then Lordship, delay in trial. Lordship, I placed one judgment, a full bench of Honorable Supreme Court, this is in Kalyan Chandra Sarkar versus Rajesh Ranjan. Reported in 2005 to SEC page 42, paragraph 18.
Kalyan,
Kalyan Chandra Sarkar.
there are two cases of Kalyan.
Yes, Lordship. One is of 2 judges, one is 3 judges.
Kalyan Chandra Sarkar versus
Versus Rajesh Ranjan, alias Papu Yadav. Date of judgment is 18/1/2005.
what is the citation?
2005 to SCC, page 42.
Yes.
Paragraph 18. Lordship, I'm sorry, Lordship.
No, you may read it.
I'll
I am
read slowly. Paragraph 18. It is retail law that personal liberty cannot be taken
not
away.
so slowly that you exhaust the time.
No, Lordship.
Okay.
The retail law is that the personal liberty cannot be taken away except in accordance with procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates deprivation of personal liberty by procedure established by law. Under the criminal laws of the country, a person accused of an offense which are not bailable is liable to be detained in custody during the pendency of the trial unless he is enlarged on bail in accordance with law. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. But even persons accused of a non-bail offense are entitled to bail if the court concerned comes to the conclusion that the prosecution has failed to establish a prima facie case against him and or if the court is satisfied for the reasons to be recorded that in spite of existence of prima facie case, there is need to release such persons on bail where fake situations required to do so. So Lordship, yeah, different councils have produced different judgments. One Muhammad Muslim, one Ravi Prakash, where it is stated that when there is a violation of Article 21, then rigorous of Section 37 will not come into play. My submission, compared to my submission, where non-bailable offense is involved, and when a heinous crime is there, Lordship, Article 21 will not come into play. And Lordship, in many judgments, Supreme Court, that full bench judgments said that Article 37 is mandatory and that is to be complied with in every case, Lordship, where commercial quantity is involved. And Lordship, with regard to delay in trial, recently, Lordship, today, in Allahabad, High Court Bar Association versus Union of India case, state of UP, the full constitutional bench has said that Lordship, delay in trial cannot be a ground for granting bail. And Lordship, in that,
Which para?
Lordship, full copies with your Lordship in this.
Okay, you just mentioned para.
Yes, I'm mentioning the paragraph. That is Lordship, the name of the case
The
is High Court of Bar Association versus State of PP.
citation.
Lordship reported in Supreme Today, 2024. 0 Supreme. Under bracket SC, page 169. Paragraph 28, 31, 32.
You have given a copy of that.
Yes, I given copy to you, Lordship.
Para?
28, 31.
No specific para. Where?
Yes, Lordship. Paragraph 28, 31, 32, and 37 C. Here, Lordship, Honorable Supreme Court has considered two aspects of the matter. Actual matter relating to that ASIA surfacing, where Supreme Court held that the stay order granted will be expired after completion of 6 months. That was reconsidered. And while considering this judgment, Honorable Supreme Court has considered many questions of law. And one was that stay order will not vacate, it will continue. But regarding direction to the trial court for completed trial within a specified period, that Supreme Court deprecated. That
No, whether any observation regarding bail was made in this case.
yes, Lordship, in one paragraph it is there.
Which para?
Lordship,
That is the relevant passage. That
I'm listening.
which you want to rely upon. That
That was the Lordship.
delay in trial would not entitle an accused to get bail. That is your submission.
Yes, Lordship.
Where Supreme Court has observed so.
The specific that word has not been used by Supreme Court in that judgment.
Bail was discussed. That benefit in bail.
In paragraph 31, last. When we exercise power directing high courts to decide cases in a time-bound manner, we are not aware of the exact position of pendency of the old cases in the
No,
state courts.
not-
Let's say, which requires priority to begin. Bail petition remain pending for a long time. There are appeals against conviction pending where the appellants have been denied bail. That objection is made. And recently in one judgment that is pronounced on 30th of course, that is not relating to directly bail. That was the accused was convicted. Then High Court suspended the sentence and he was granted bail. That judgment I'll also place. Probably, let's say 24-30 years there.
How much time will you require?
Another 15 minutes. Maybe it's tomorrow also.
Okay, we'll continue tomorrow.
Yeah.
We'll continue tomorrow. In item number
4, 7,
4, 7, and
Eight.
8. Item number 4, 7, and 8. Heard learned counsel for both the sides. Hearing remain inconclusive. Let this matter be listed again tomorrow. That is 14/5/2020.
My lord, this 2005 2 SCC 42, which the prosecution is relying. My lord, I'll give a copy of this tomorrow, my lord.
You'll get chance to reply.
I'll give a copy. So.